My name is Anthony Salinas, and this is the module number 4 discussion. First question, what role do grand juries play? Well, much like the role of the judge in a preliminary hearing, grand juries are responsible for determining whether the case of the accused should go to trial after hearing the facts of the case as they are presented to them by the prosecution. If the grand jury deliberates and believes the suspect should be held for trial, they will usually return with an indictment or a true bill, which means they find the charges brought against the suspect to be substantial enough to warrant a trial. But if the grand jury finds the evidence presented to be insufficient and therefore does not justify a trial, they will return with what's known as no bill, meaning no indictment or true bill. Do grand juries violate the constitutional rights of witnesses and defendants? Well, according to the grand jury clause of the Fifth Amendment, which was ratified in 1791, grand juries are legal and constitutional. However, there are aspects of a grand jury that seem unconstitutional. First, because it's not technically a criminal proceeding, the right to counsel does not apply. Defendants might not even be present for the grand jury, and even if they are, they're not allowed to make any statements to the jury, address the jury, or present their side of the case. Grand juries are also held in secret, which is said to be done in case the grand jury is unable to find sufficient evidence to indict, which would protect those under investigation from public scrutiny. But witnesses themselves can avoid incrimination by pleading the Fifth and are allowed to consult with their attorneys, with some even being offered transactional immunity for their testimony. But these witnesses are subpoenaed to appear before a grand jury, with a failure to comply with the subpoena being seen as being in contempt of the grand jury, which results in fees or often imprisonment until they eventually comply. The contempt power, as this is known, can also be abused, with prosecutors subpoenaing a witness knowing well that he or she will refuse to testify, and then they will have the witness jailed. Some prosecutors call political dissidents to testify to find out information completely unrelated to criminal activity, simply because they know they won't testify and will be imprisoned. This has happened mainly to newspaper reporters who refused to give up their sources after being summoned as they believed it would violate their First Amendment rights. But in 1972 in Brandsburg v. Hayes, the Supreme Court ruled that journalists must testify before a grand jury. Grand juries therefore allow people and uncooperative witnesses to be imprisoned without trial, because so long as the grand jury is in existence and the person refuses to comply, they can be imprisoned indefinitely. Which leads to the question, do you feel the prosecution has too much power in the grand jury process? Yes, I feel the prosecution has entirely too much power in the grand jury process. In addition to being able to imprison people through technical legal loopholes, in theory at least, the prosecution should just be a legal advisor to the grand jury. But in practice, it seems the prosecutor has a great deal of power and influence over the courtroom and its proceedings. For example, grand jurors themselves only hear from the witnesses that the prosecutor summons. And as lay people, or people unaware of standard technical aspects of proceedings, they can be heavily influenced by their argument. For instance, as Professor Lewis mentioned, because they have the burden of proof, the prosecution is allowed 2 closing arguments, unlike the defense, who is only allowed 1. Grand jurors can mistake this for the defense not having a strong enough case and potentially be swayed in favor of the prosecution's argument. Often, grand juries seem to just simply indict whoever the prosecutor wants indicted. One study even found that the average time spent per case was only 5 minutes. In 80% of those cases, there was no discussion by members of the grand jury. Rarely did members voice a dissent. And finally, the grand jury approved virtually all the prosecutor's recommendations, with federal grand juries rarely returning no true bills. Sol Watler, former Chief Justice of New York Supreme Court, said, quote, "Any good prosecutor can get a grand jury to indict a ham sandwich." This overconfident hyperbole was of course meant to be a joke, but it shows the prosecution themselves are well aware of the amount of influence they hold over grand juries and the proceedings. And in 1973, William Campbell, the U.S. District Court Judge for Northern District of Illinois, said, quote, "The grand jury is the total captive of the prosecutor who, if he is candid, will concede that he can indict anybody at any time for almost anything before any grand jury." So at this point, it seems the role of the grand jury seems to be less impartial arbitrator and more of just a formality for the prosecution to inflict their judgment.